Okay, welcome everybody. And Peggy, thank you for that moment of silence. And before I start my presentation, I will ask if everybody will once again join me in prayer for the Cotton family. This morning on our Realtor prayer chat, Siska Hoitapia shared a wonderful and I think in touching prayer that I'd like to share with all of you. So if you would please join with me once more as we remember our former leader, our friend, our associate, our mentor, Mo Cotton, and his family. Please join me and bow your heads. Blessed are you, O Lord, our God, who gives life and takes it back. Lord, the earthly loss of Mo causes us to mourn. Yet for those who know our Messiah, we know that Mo is in a far better place. Please comfort the grieving Patty and her family with the hope of reuniting with believers for eternity. Blessed are you, O Lord, who comforts those who mourn. In Jesus' name I pray, amen. Thank you, everyone. And I pray that all of you who are attending this session today will be blessed by the information, that it will help you to be the best agent that you can be in serving your clients and the real estate community of Guam. So again, thanks for joining. Today we are going to go over the listing agent's role in the selling process. And we will cover the first phase of what I call the selling process is preparing the property and your owner for market. And secondly, scrutinizing the offer, the purchase agreement once it comes in, and guiding your seller through the escrow process. Next slide, please. Now, when I get a new listing, when an owner has entrusted me with the selling of their properties, one of the first things that I ask myself is, am I the best agent for the job? And I ask a few things of the owner and the situation. Number one, what are the owner's, sellers, and expectations in selling the property? I always like to ask people, what do you think your property is worth? And who do you think will be the most likely buyer? I also ask myself, what does the owner, seller expect of me? And I'll be able to glean that information once we've had time to sit down, get to know each other, and talk. In that process, I ask, do our personalities match? Do they complement each other? Or do they oppose each other? Because it is really important that you and your client connect. And a lot of times in the past, I would ask people once, when they come to me and wanting to sell their property, I do ask them, have you shopped around with different real estate brokerages? Because you should be comfortable and confident with your agent and feel that you guys mesh. Another thing that I do ask is, has the property been on the market before? Were there other listing agents? And were there issues surrounding the property? Why did it not sell? Sometimes reaching out to the former listing agents will help shed light on that. And I do ask myself sometimes too, after I've gotten all the information, should I pass on this listing? Am I the best agent for the job? Will I be able to best serve this particular seller client? And in some cases, it would be best for the whole experience that I consider to bring in a co-listing agent if I feel that I may not alone be able to best suit, or not suit, but serve the interests of my client. Bring in more heads together. Okay, next slide, please. And just a reminder, all these things that I'm going over right now with you are questions that I ask myself in help developing the listing, which will inevitably help me to determine my seller's needs, the best way to market the property, and basically how to service the client the best. The next question that I ask is, what is the seller's motivation to sell? Because a lot of times this will help determine what kind of time period I'm working with. If I am having to deal with off-island owners and really essentially see what is motivating the seller to sell. Some of the cases will be, or circumstances will be, there's merely upgrading, moving to a bigger house, their family has grown. Or two, just the opposite, their family, they're empty nesters and they need to downgrade. Some people are relocating off island. And with those families, time really is critical to them because a lot of times they need to sell here in order to purchase elsewhere. Another situation that may have a time crunch is your seller is in financial crisis. They need to liquidate. Some are facing foreclosure. Some have to probate, which you know probate takes time. Does the seller have time for that? Sometimes they want to sell because they own the property with somebody else and now they're in conflict and they don't want to be partners together. And others merely want to upgrade their assets portfolio. Again, all of these motivations will influence market time, pricing, how you're going to market the property, and what ultimately will be their pool of buyers. Next slide. It's important to know who your owner seller is. You'd be surprised. In my experience, and I've been a realtor now since 1984, there are many different forms of ownership as you see listed here. And it is important to know that who you are talking with and who will be signing the listing agreement are all the owners that you need. You will be dealing with individuals. Some are married couples. Sometimes you have co-owners that are not married. There are partnerships, limited liability corporations, regular corporations, trusts, probate estates. Sometimes minors are listed as an owner, and sometimes we have government entities. So it's important to know who your owner is so that you know who you are, that you are dealing with the authorized seller of that property. Next slide, please. So once you've confirmed who the owner of the property is, you need to confirm their right or authorization to sell. And this can be verified through various means. In the case of individuals or co-owners, a deed or a power of attorney if somebody is acting in behalf of a principal. With corporations, it's good to get a copy of the corporate resolution and the minutes in where that resolution was made that confirms who was the duly authorized representative of the corporation and their rights to sell the property. And usually in that resolution, they may also tell you what price that they are authorizing the property to put on the market. Partnerships also may have the same thing, a partnership resolution or minutes, again, to confirm the authority of the representative that you're dealing with in selling the property and any terms and conditions. In the case of a probate estate, it is important that you get the testament letters that affirms who the administrator or the executor may be of the estate who can act in behalf. Also in a probate situation, we will need court documents confirming the approval of the listing, the listing agreement, and also the terms in which the property is to be put on the market. And if you are dealing with a trust, the trustee documents will show, the trust documents will tell you who the authorized trustee is to act in behalf of the trust in selling the property. So it is important to know from the beginning, because it will save you a lot of problems later on, who the seller is, and to ensure that you are dealing with the right person or persons. Case in point, recently, I had a buyer, we made an offer on property, only to find out that the listing agent was not in communication with all of the owners of the property. And we found out at that point, once the offer was submitted, that one of the owners was not in agreement in selling the property, or at least for the price that the rest of them were willing to sell. So it is important, again, I can't stress enough, to know who the owners are, make sure that you have had contact with them, and that everybody is on the same page and of like mind in selling the property. And one thing I forgot to add on this slide was, when you're dealing with government entities as a seller of property, it is important to find out, not find out, but to confirm, again, the representative that you're dealing with, that they have full authority to do so in behalf of the government entity. That can come in the form of I'm really not sure what kind of authorization letters would be, or documents would be issued in that case, but I do know that they are available, and you would have to confer with the person, especially if you're dealing with a foreign entity, a foreign government. It may come through their consulate, an embassy, and certainly would have the seal of that embassy or that consul in order to sell property. Okay, next slide, please. Another thing that I look at when I take a listing is to ask if there are any special terms or conditions or external circumstances that will affect a listing. And some of the things that I've run into in the past is if an owner wants to keep possession of the property till a certain date, because that pretty much determines the selling time. Sometimes this may be that they don't want to actually close until a certain date, or they don't want to deliver possession until after closing. So it's good to ask those questions so that you know how to approach and deal with that matter. If an owner or seller has no money to perform duties or clear liens and encumbrances, that should be addressed also. And how will that be, how does that affect a listing if something needs to be cleared before escrow, before proceeds are obtained? Help your seller in addressing those things and advising which way may be the best way to handle those issues. Sometimes we run into missing owners, and that can create a big problem too in trying to locate owners. Some of us may have run into that. It may take some research and tracking down where the owners are, and you can run into situations where maybe an owner that is still showing as being an owner on record may have passed away. How do you deal with something like that? Oftentimes it would require having to go to court to declare that owner deceased in order to be able to continue on with the closing. Probates. It's a good idea to ask your owner, especially we see here on Guam, especially if it involves land, especially returned lands. Does a probate need to be opened? Because that will certainly add time to your selling process, your closing, your escrow process, and also the pricing of the property. Because as we all know that when properties go through probate, the courts require that an appraisal has to be done and that the listing should be at least 90, no, I'm sorry, not the listing, but the sales price should be at least 90% of the fair market appraisal value. Another question to find out, ask is there any litigation, pending litigation or third-party claims of interest against the property? Because you would want to try to deal with that or understand that before putting the property on the market. Another question I ask a lot of my owners, especially if they're selling investment properties, is do they have any tax questions? Are they aware of capital gains taxes? Do they want to do a 1031 tax deferred exchange for like property? So that's a discussion that we have also. So at least I have an understanding as to whether or not the owner is willing to pay capital gains taxes right now, or do they want to be able to defer it? And lastly, special external circumstances that will affect listing is stigmata. Next slide, please. Now, stigmata is not something that a lot of people like to talk about or are comfortable talking about. However, as a listing agent, you do need to ask your client if there is any stigmata associated with the property. The stigmata are things that could affect the desirability of the property in the eyes of a buyer, especially if buyers have problems with things that are listed on the screen here. Examples of stigmata, as I found on the internet, are there's criminal stigmata. Was the property ever used as, for instance, a brothel, a drug den, or a chop shop? Debt stigmata is, was there ever a time when debt collectors were visiting the property and posting, those notices all over the property? Minimal stigmata is something that occurred on the property that is known only by a small select group of people. And an example of this may be family violence, or perhaps somebody died on the property of natural causes. Murder and suicide. That's one I think that all of us are aware of. Phenomena is another stigmata. Does the property have a reputation or a history of hauntings or possibly ghostly sightings? Lastly, public stigmata. This is something, stigmata, that is known by many and that it's been widely publicized. In researching for all the different stigmatas, one of the cases that they show of public stigmata is the Amityville horror case. I think all of you who've been, back to the 70s, this was a case that's been documented, and the books have been written about it, and also movies were made of this property, of this house, and what the family went through. On Guam, I have not really seen anything like that. There was a house in Assen many years ago in the 70s where there was a triple homicide. And for years, that house sat vacant, and it was well known by everybody. on the island because it was so highly publicized. So stigmata is definitely something that could affect a potential buyer's desirability to buy the property, or definitely influence their decisions on the property. So it is important, you as a listing agent, to ask these questions because it may come up later on, and then you'll be able to advise your seller, and you would have made full disclosure to any potential buyers. Next slide, please. Now, when I get a listing, the very first thing that I do when I get back to the office is to order a PTR, a preliminary title report, or an owner's encumbrance report, because this will help me to verify who the owner of record is, also to verify the legal description. And other information provided will be the land area, the map document number, what type of ownership does the owner hold, and any type of liens from taxes, assessments, easements, encroachments, judgments, loans, and possible claims of interest if anybody filed anything against the property. So I hope that all of you also in your office practice this, because this is really, the preliminary title report is one of the quickest ways to verify a lot of very important information on the property. And order it. We've got 3 great title companies. Order from any one of them. Next slide. Now, one of the first questions that a seller will always ask us is, what do you think my property is worth? How much can I sell it for? Now, thankfully, we have a lot of tools at our disposal to help us determine value and price, along with our experience and gut feeling. The appraisal. The owner can definitely order an appraisal from any of our professional appraisals. And definitely in the case of a property that has to go through probate, you will have to order an appraisal. Sometimes the courts may allow the Department of Revenue Taxation assessed value, but that may not necessarily be the market value. So I believe that any probate attorney would insist on getting a professional appraisal. We also have at our disposal the multiple listing service, which, as you know, is just a wealth of knowledge as far as what properties are on the market for and what they have actually sold. And also in our MLS, we have the comparable market analysis, the CMA, which will help you to do a side-by-side comparison for your owner so that they can see what properties are on the market for, which I call the competition, and also what properties have sold for. And usually I like to pull comparable data no further than the 12-month period preceding my listing. 6 months is best, but if I can't find anything of comparable, I'll go as far as a 12-month period. But I like to do both an active for sale comparable CMA for my owner and also the closed, because then that way they can see, number one, what is their competition asking and how does the competition properties compare to their home. And also the closed will show, well, this is what it actually closed for. This is what buyers paid for the property and what the terms and conditions were. Typically, the active sales comparable report will be on the higher end of the valuation, and then the actual closed comparables will be on the lower range. So that gives your owner a good range based on factual data. Next slide, please. Also, while I'm meeting with my owner in developing the listing, I like to advise them in advance of what selling costs they can expect to pay at the closing of the property. And that way there's no surprise to them and they can prepare for that. I discuss with them what their loan payoffs are if they have a loan on the property. Is there any recapture interest? We don't see recapture interest so much in a lot of the loans from the bank, but there is recapture from loans that were given through the USDA direct program, and also from way in the past when they were known as the Farmers Home Loan Program. Because as you know, these type of loan products are based on an owner's capability to repay a loan, and the interest on the loans were often subsidized to be repaid at a later point in time. And usually that later point in time is when the owner is going to sell the property. So if you get a listing that has an old farmer's home loan on it, or from the USDA direct, you need to find out if there is any recapture interest that the seller is going to have to pay in addition to the principal. I discuss with my owner commissions, escrow fees, notary and document preparation fees, any type of other lien payoffs such as property taxes, prorated taxes, if there are any judgments or claims, survey costs, if the purchase agreement calls for them to perform a survey. The same with pest inspections and treatment of pests if they're found. Any type of repairs or any other type of inspections that may be required of a seller. So I'd like to kind of go over these and give them an idea so that they are prepared. Next slide, please. And this is a sampling of what I do with my owner at the time of listing, and explain to them again, as I mentioned, the possible costs that they would have to pay that's going to be associated with selling. Survey of boundary corners run anywhere from $900 to $1,200. Pest inspections about $125. And then you have the whole list of seller escrow closing costs. Now I've just plugged in here some figures just to show, but explain to them how escrow fees are normally shared, what they can expect to pay as far as document preparation, because typically your seller will be paying for the preparation of the deed, and then there are other documents such as affidavits and things of that nature. What notary fees may run, and recording fees if they have a release of mortgage, and you want to make sure that they remember to get their release of mortgage and when they pay it off. What the title company charges for title reports, if they're going to have proceeds wired to them, what that fee will be, any type of courier services, commission fees, okay, and what you've negotiated with them, and prorated property tax. The other cost deductions that they can expect to see at closing will be their existing mortgage, and if they negotiate any seller credits to the buyer. So I like to go over these things with my owner at the beginning, at the onset of the listing, to prepare them so that there's no surprise later on, and that they can, figure and account for these costs. Okay, next slide. Now, when gathering detailed information on your listing, MLS has within it the property input forms. And this is a wonderful form to use because it essentially gets you all the information that you're going to need to transfer onto the MLS data sheets. So I encourage you to go into MLS, and if you haven't already been using the input forms, excuse me, to use it, excuse me, and if not, then at least at the very minimum, use the MLS data sheet as your guide in what information you need to gather in preparing your listing. Okay, next slide, please. Okay. The input form in MLS consists of it's quite detailed. I have it over 3 different slides here. Okay. We won't go in great detail. You know all of this information, but it's just to let you know where you can find this input form and how to use the MLS data sheet as well as putting together your details. Next slide, please. Okay. Okay, next slide. Okay, marketing considerations. Now that you've gathered information from your seller about their needs and also all the details on your property, on your listing, now you need to consider what will be the best marketing media for this listing. All real estate is unique. All have different needs. And we have at our disposal now various ways of marketing the property. You need to consider your listing, its qualities, and the needs of your seller. You need to identify the pool of market buyers that will most likely purchase this property. And you need to assess your listing. Is the property ready for sale? In order to attract the widest, the largest pool of potential buyers. Are there any issues, or are there lots of issues that need to be resolved before you put the property in the market? Because as we all know, issues affect the desirability of the property. It brings down the value of the property in the eyes of the buyer, as a buyer will always compute. What is it going to cost me to resolve these issues if I agree to buy this property with the issues? Are the issues resolvable to reach the greatest share of the target market? Is the seller able to financially take care of these matters, or have the resources in order to find out how and where it can be resolved? Okay, and if these issues can be resolved, it is best to do it before putting it on the market in order truly to be able to obtain the highest value, and also to be able to have the cleanest escrow. Okay, next. Some of the marketing tools that we have in order to promote and give our listings the most exposure: photographs and videos. And now we are able to post photographs and videos on the internet and on social media. I would like to mention that when you take photos or videos, please remember to put down the toilet seat, or at least the cover. We see so many photos where the toilet seat is left up, and that's just not something I think that is it shows the property in the best light. And when you are taking photos or videos, I think it is important to make sure that the rooms and the properties are really shown in its best light, because first impressions are the most important. And sometimes I will forsake taking pictures of some rooms in a house if I see that the owner is unable to fix it up for a photo ready, or if the room is too small, and try to focus on other parts and other features of the property. Definitely when taking photos or videos, the rooms in the house should be in its best presentable condition, okay? Free of clutter, personal items put away, beds made up, clothes put away in the closet and the closet doors shut, shower curtains shut, and counters cleared of clutter. Because remember, again, first impressions are the most important. We also have available to us print advertising, although we do not see too much of that in the newspaper anymore or in magazines. we see more on the social media. I'm jumping down a little bit. Social media advertising. Signage is very, very important. In my experience, I get more inquiries from buyers because they saw my sign posted, and I'm sure that is the same for all of you. Open houses. You can do a public open house, or you can do just a broker open house. In recent years, I see that most agents are doing only broker open houses rather than public open houses. And I understand the reason for that. A lot of it has to do with safety and being able to really qualify who is coming to the house. Because in a public open house, obviously it's open to the public. You cannot determine in advance whether or not the people are coming through are just there for their weekend tour of homes and whether or not they're really qualified. And our objective really is to show the property to people who are qualified. And also, I think the most popular tool that we use is our multiple listing service, because with MLS, we give immediate exposure of our listing to over 400 agents who, if each one of them has at least 2 possible buyers, you've got right there exposure to over 800 people. So I strongly encourage my sellers, whenever I take a listing, is to allow me to put the property in the multiple listing service to have that great pool of exposure. Okay, next slide, please. So now we're going into the heart of the residential listing agreement. Everything that I talked about prior to this slide here really is to help you to prepare, to prep in developing and formulating your listing agreement. And for the purposes of this training, we're going to focus on the residential listing agreement. There are other listing agreements, the vacant land listing agreement, the commercial listing agreement, and I think if there's an investment listing agreement, rental listing agreements, but those will be all for another day. Today, the residential listing agreement will be reviewed. Okay, next slide, please. Now remember, in our business, we deal with contracts, both at the listing period and also at the purchase period. So this is just a reminder of what the essentials of a valid contract is. Okay, you have an offer where somebody says, will you do this for me? And you have an acceptance. The other party says, yes, I will. So you have an offer and an acceptance. You have a meeting of the minds, an agreement as to what the contract is going to consist of, what the duties are, what the expectations are of the parties, the meeting of the minds. You have consideration that there is something tangible that is being contracted for. Okay, the benefits are going to be received from this because of consideration. That the people involved in the contracts are of capacity. They have legal capacity, and they are able to, of right mind, be able to enter into a contract for terms and conditions. That what you are contracting for is a legal activity, okay? Selling homes, leasing homes is a legal activity. And the written document helps to lay everything out so that there's a clear understanding, and if needed, if the time came, it becomes an enforceable instrument, okay? Next slide, please. Okay, I think it is really important to explain the terms and conditions of the listing agreement and to allow your owner, seller, time to review and understand the terms and conditions of the listing agreement. I always encourage them to ask questions. I always tell them, no question is an unimportant question. All questions are important, and to have discussion with them. And a lot of times I like to leave the listing agreement with them to allow them time to review it. And in particular, if you are dealing with an owner that is taking advice from another family member, that you want to make sure that that family member is included in the circle, okay? Because that tells you that your owner, who is the owner of the property, is not making the decision solely on their own, and that they are looking to the support of someone else. So you want to make sure that that person is included in the discussions and that they understand everything that's going on as well. And if necessary, and you will gauge from your interview with your owner, perhaps they should take the listing agreement to an attorney for review, or in the matter of income tax questions, that maybe also include an accountant to review the documents as well. Okay, next question. Slide, sorry. Okay, the residential listing agreement. And here on this slide, again, we're just going, basically it's page 1 of the listing agreement. As I said earlier, identify who your client is, okay? And the name of that client. And these are all the different potential clients, okay? The price. Hopefully you have discussed with your owner, prepared the comparable reports. Perhaps you had an appraisal done on the property, and you've arrived at the price that the both of you have decided would be the good listing price to start with, okay? Also, terms of sale. It's important to discuss with your owners, I feel, as to what their expectations and what their needs are, okay, at the closing table or from a purchase agreement. Do they need all cash at the close of escrow, okay? An offer that comes in that's subject to loan is all cash, because in the end, they do get cash, although that cash is conditioned on the ability of the buyer to get the loan, okay? Is your owner willing to do owner financing? Sometimes that works for an owner as well, okay? But it's a question worth asking. And if they do owner financing, can they do a contract of sale, which basically really protects the owner of the property while the owner financing is being carried out, because they retain the title to the property. Okay, it does not get conveyed to the buyer until the buyer satisfies the contract of sale in its entirety. The contract of sale is recorded at land management to show that the buyer has an interest in the property. However, if the buyer should default on the contract, the seller still retains the title because they haven't transferred it yet, and they just have to file the necessary default notices and declare the contract of sale null and void, and record those at land management in order to remove that contract of sale lien against the title of the property. Sometimes a mortgage and promissory note under owner financing is the more appropriate means of carrying owner financing, especially in the situation where a buyer may have put a substantial amount of money as a down payment. Okay, usually on a contract of sale, I'll go back to that, the buyer initially puts very little money down, so that's why they don't get the title yet. Okay, on a mortgage with promissory note, typically the buyer has put down a substantial amount of money, and therefore the seller conveys the title, but then their collateral is that the property is then mortgaged with a promissory note from the buyer to pay. The property is secured for the benefit of the seller of the property, although they don't have a title anymore, but they have that mortgage, which is a lien against the property. And it pretty much operates the same way as a bank would. And if the buyer does default, then the seller goes through the foreclosure process, just as the bank would do. Okay, so it's good to talk about those things as far as terms of sale and what is most desired by the seller. Okay, next slide. Okay, compensation to the broker. Very important to explain the commission agreement to the seller. Okay, number one, commissions are negotiable. Remember that, folks. I know we have an industry standard, but commissions are not to be fixed by law. For an industry to fix it, we would violate antitrust laws. So commissions are negotiable. Talk with your principal broker as to what your office policies are and discuss that with the seller. Okay? Explain to a seller when a commission is earned. And this language is clearly stated in the commission agreement addendum, but also within the body of the listing agreement and also in the purchase agreement. Okay? Explain how the commission is paid, because a lot of people I found out in the past think that they have to pull that money out of their pocket outside of closing. And so put their minds at ease and let them know that that's typically paid at the end. Okay? Explain to them co-brokes and how that works when two agencies are involved in the sale. I always like to tell them that co-brokes are wonderful because you get two real estate offices involved in the sale of your property, and you have more real estate agents with their professional minds at work for both you and the buyer. Okay? Now, I think it is also important, and maybe a lot of people don't talk about this, is what happens when there's a default situation. And the commission agreement clearly does state what happens in a default situation and how is the broker compensated for the time and effort that's been put into a transaction. What happens with the earnest money deposit? Or if the transaction ended up in suit and the seller was awarded damages, who does that money go to? A lot of sellers think that they are entitled to all of that money and that as agents we lose out. But our commission agreements and language anywhere that addresses compensation to brokers clearly states that in a case of default, or if something goes to court, that there is a sharing of that money, of the earnest money deposit or damages between the seller, owner, and the real estate brokerage. Subject to, of course, less deductions of expenses that the seller may have incurred and cannot get back now because of the default. But I think it is really important to educate your sellers about that so that later on down the line, there will not be any surprises. Next slide, please. Okay. These are all other terms and conditions that are stated in your residential listing agreement. A lot of them are very self-explanatory, but I think it's important just to make sure you talk about these things with them, okay? Multiple listing service, explain the opt-in, opt-out, but really that I would expect every agent to encourage placement of posting of the property in the multiple listing service, okay? Go over broker's duties and the seller's duties and what is expected of each other during the listing period. Agency relationships, okay? Dual agencies with a buyer. Explain how that works to your seller, that there may be a situation where you are going to represent both seller and the buyer and how that affects really the agency relationship and the duty to also represent the buyer fairly. Personally, I prefer co-broke situations over dual agency. You make more money in a dual agency. However, In a co-broke, you better represent your seller in negotiations and in the selling process. I think it's also important when it comes to security and insurance and lockboxes that you discuss with your owner to make sure that their insurance policy, if a lockbox is placed on the property, doesn't in any way violate any kind of coverage if property is burglarized or damaged, vandalized, because a lockbox was placed on the property, okay? Find out, tell them to contact their insurance agent just to make sure. And if there are any issues, if they need to increase their coverage in order to protect against potential problems because the property is being made accessible to people, agents, that they make the adjustments, okay? But it is a question worth inquiring with their insurance provider, okay? Equal housing opportunity. You've got to explain the Fair Housing Act and how we cannot discriminate. We cannot discriminate against any buyers based on what fair housing dictates. And if a seller asks you to do that, that is a big red flag and a very good reason to walk away from a listing, okay? Explain to them dispute resolution, in which we have mediation available to us, that the Guam Association of Realtors also has the grievance professional standards process available to them to avail of. And also, oh, I can't see the bottom one. Oh, standards, so sorry, professional standards process. Explain attorney's fees, the earnest money deposits, and other additional terms. And I've underlined here, subject to broker's approval. Remember, folks, the listing is the property of the principal broker and the brokerage. It is not the property of the agent who takes the listing. So whatever listing you put together, you must have your principal broker review it to make sure that they approve of the terms and conditions that you are committing to an owner or seller of property. And also explain to your owner that in the event they pass away, that that the listing agreement is binding to their assigns or successors. Okay, next page. Seller's advisory. Now, I've kind of gone through the seller's advisory, which comes along with our listing agreement. Things that are points that are of importance, I think, in going over with the seller. Disclosures, okay? Sellers are required to disclose known facts of the property that may affect the value or the desirability of the property. They are required to disclose if they know of any deaths that occurred on the property, and other disclosures may be stigmata. And again, disclosures are things that are known facts, okay? The seller, owner knows about it. Seller's not required to make discovery of problems that they are not aware of, but they are required to make disclosure of things that they know about, okay? Other disclosures, if you're dealing with the condominium property, of course, is to obtain the condominium documents, the homeowners association bylaws, the HPR if necessary, if it's called for, also house rules, okay, and financial disclosures of the condominium association. Explain to them about contract terms and legal requirements, okay? Do they want to do repairs or do they not want to do repairs? But remind them that the more repairs are needed on a property, it's definitely going to affect how a buyer reviews or sees the property. That discrimination is prohibited, as we mentioned earlier, okay? EPA, lead paint, renovation repair, and the painting rules, this is the lead paint disclosure. Any kind of legal or tax implications, if they have questions about legal matters in legal matters or in accounting matters, tax matters, that they should seek the proper professionals for advice regarding those matters. And you can help them to direct them to where they can go to find that information, okay? If there are known problems in the house and they don't plan to correct them, well, then be sure to disclose it, okay? And always, since the property is going to be made available for people to come and view, buyers, prospective buyers and agents, the seller has a duty to keep the property safe. If their walkways are moldy, and especially we're going into the rainy season, they need to clean that mold off so that it will be safe to walk on surfaces. If there are rebar sticking up out of the ground someplace, they need to remove those things so that will minimize chance of anybody getting hurt. Showing is being conducted, okay? And also that any of the expenses that are, that have to be covered, that it is the seller's responsibility to get that done and not the broker. Okay, next slide. And lastly, on the listing process, COVID-19 has brought a new process for us, new things to consider. And I know most of you, if not all of you, I hope, have attended all the COVID-19 training that we've had in the last few weeks. I understand there was one last night as well. So I'm not going to go over into detail because you've already gotten all the details. But as a reminder that these are the different forms that we need to include in our listings now, in our showing processes as well, for both buyers and sellers, tenants, anybody, basically, these declarations and these addendums. So be sure that you don't forget to include these forms in there. Okay, next slide. Okay, so now that you have you got the listing, you prepared it, you got all the details, you've advised your seller, you've gone through the marketing process. Now the offers are coming in on the property. So now we are going to look at examining the offer under a magnifying glass from a listing agent's perspective. Next slide, please. First thing to ask when you receive an offer is, how strong is the offer or offers in the case of multiple offers coming in? And how well does the offer meet the needs of your owner, your seller, and also the terms and conditions of the listing agreement? Next slide. Things to look at when the offer comes in. Again, who is the buyer? Confirm the buyer's authority to make the offer, just like you confirmed who is the owner and what was the owner's authority to sign the listing agreement. Same principle applies in the purchase agreement, okay? Because you want to make sure, especially if the buyer is not an individual, but maybe a corporation or a government entity or a partnership, okay, that whoever signed the offer has full authority to do so. And you want, as the listing agreement, to have those documents along with the offer that will substantiate their legal authority to act as a buyer or to sign in behalf of the buyer, okay? Make sure your lot number is correct and the address. It's a good thing, a good point to make sure when you get the listing as to what the physical location, the physical address is per what the Department of Public Works has. Some people are still using the old system that was issued by Guam Cable TV years ago. And sometimes you'll find houses with 2 numbers on it. confirm the legal, what I call the legal physical address through the Department of Public Works, okay? And I like to put on the offer also, what does the property consist of? Is it a 3-bedroom, 2-bath house on a 1/4 acre? A 4-bedroom, 2.5-bath house on a 1/2 acre? So that there is a clear understanding not only of the legal description, the physical address, but also what is the buyer buying for? What is the buyer buying? Okay, the closing date. Typically we see a lot of 60-day closings, which are tailored towards the approximate time that a bank will need to process the loan, and also all the other stuff that goes along in the buying process. But you need to ask yourself as a listing agent, does this time frame work for my seller? Hopefully in your interview with the seller when you took the listing, you were able to determine from them why their motivation to sell, the reasons for sell, does that time frame work for them? For some, 60 days may be too long, or it may be too short, okay? So be sure you review that to see how well it meets your seller's need, okay? And again, on the first page, it tells you who what brokerage represents which party. And again, I am an advocate and I like co-broke situations, okay, because both parties have their own agent representing themselves. Financing terms, okay, from a selling agent's perspective, the more earnest money deposit the buyer has put down, the better for my seller, okay, because it shows, I think, truer intent on the buyer's part, and also in the event that there is a default, okay, by the buyer, I've been able to secure a higher deposit that my seller can claim, okay? So more is better from the selling agent's perspective, okay? Understand if the offer is conditioned on loan financing, find out what type of loan product is the buyer applying for. From a buyer's agent perspective, we like to put things kind of a little loose to give our buyers some flexibility. But from a seller's standpoint, we want to know really the particulars, the details. Does the buyer have to put up any kind of cash down payment? Where is that cash coming from? Okay, how available is it? So you need to ask those questions as a selling agent. What type of loan product is it? Because each loan product too will have different ramifications for your seller, okay? And you're going to need to know those to explain that clearly to your seller and what this offer is going to require and expect of them, okay? And always, if you can get a pre-qualification letter from the bank that the buyer is going through to apply for, get that letter in as quickly as possible, okay? Because this will affirm at least that the buyer has submitted financial information to the bank. All of it's still subject to final confirmation by the lender, but at least you get a good, comfortable feeling, okay, based on the buyer's earnestness to submit all that documentation to the bank. And it gives you a little more security than to not have that letter, commitment letter from the bank. Okay, next slide. Okay, explain to your seller how costs in a offer is going to be allocated, okay? Does the offer require the seller to pay for any costs? Can the seller pay those costs outside of escrow, okay? What inspections or reports are being required of the seller? If there are any government requirements in retrofitting. Now we say a lot of times that this doesn't apply too much to here on Guam, but I always kind of think, what if during my escrow period, something in the law comes up that's going to require a seller, an owner of property to do to their property before they can sell it, and they make it retroactive and we're caught in the middle, okay? So it's important to discuss that clause to your owner to help them understand what kind of ramifications there may be, if any, okay? Explain to them the escrow and title fee costs. Again, how escrow fees are allocated, okay? Title costs for the title report, and also other costs that may be associated for survey, septic tank inspection, professional cleaning. And now we may begin to see where buyers may, because of COVID-19, require sanitizing, professional sanitizing of the property, okay? But in that section of the purchase agreement, allocation of costs really address, number one, what the cost to do inspections, and not necessarily what the cost will be to perform treatments if treatments are recommended. Because usually if treatments are recommended as a result of the inspection report, that becomes a negotiated item. But sometimes in this section of the purchase agreement, the seller to perform the survey is inserted in there. So you would need to advise your seller of what the potential cost is for the survey or a septic tank inspection, okay? Next slide, please. The closing and the delivery of possession, okay? Again, I ask, is the escrow period, the 60-day closing from acceptance, the 30-day closing or the 90-day closing, is this a beneficial time to meet the seller's needs, okay? You need to discuss that with your seller and try to tailor the offer to what that time frame would be, either in a counteroffer, okay? Number two, is the property tenant occupied, okay? Does the purchase agreement call for the tenants to be vacated before 5 days before closing? You've got to discuss that with the seller, okay, to figure out how that's going to be done. And if they can't do it, then you're going to have to come up with perhaps a counteroffer and how that's going to be handled, okay? And if the seller is occupying the property, to help them to understand that at the day of recordation of the closing documents, that the house must be ready, cleaned up, all their stuff moved out, and be ready to turn the keys over to the new owner. Okay, next slide, please. Statutory disclosures, okay? Lead-based paint disclosure is required by law. Parties cannot waive this disclosure for homes that were built prior to 1979, okay? And also, along with the lead paint disclosure, if it applies to the transaction, be sure to include the form FLD, which is in our zip forms, but also you need to give the buyer the pamphlet, okay, that educates a buyer on the potential hazards of lead paint. And that is what the law requires. It's not only the lead paint addendum that we attach, but also you as the listing agent ensure that the pamphlet gets transmitted to the buyer's agent so that they can give that pamphlet to the buyer. And this pamphlet can be found online. You can print it. I think it's maybe a 8 or 10 page pamphlet, but be sure not to forget to do that, okay? Next slide. If the property that you're selling is a condominium disclosure, the seller will be required to provide condominium disclosures. These forms can be obtained from the homeowners association office, or in the case if they have a real estate office managing for the homeowners association, you can contact them. for all the necessary condominium disclosures that we mentioned briefly earlier, which would include the condominium bylaws, HPR, the horizontal property regime, if required, covenants and restrictions, house rules, and also financial disclosures, okay? These usually come up to quite a bit of documentation, so notify your seller. Expect to have to pay for these. They can range anywhere from $25 to $50, I think, to get copies of all of these documents. Okay, next slide. Okay, what is going to be included and excluded with the sale? These are the personal property items. And you see that I put on the slide, I put appliances, cars, artifacts, fixtures. And I have to share with you, years ago when I had a listing, at the showing, my seller, bless his heart, was so excited about selling the house or having the first showing that they got so excited, and they were there when the buyers came. And I found out in the course of the showing, my sellers offered to include 2 old but working cars in the transaction if the buyer made an offer. Okay, that was not in the listing agreement. However, they made that commitment. And so when the offer came in, lo and behold, there, along with the refrigerator, the stove, and the washer and dryer, were 2 cars. Needless to say, I was not happy with my seller, but in the end, it worked out for them, okay? But it's important to know in your listing agreement earlier to discuss what is going to be included with the sale of the property, aside from what is typically expected, which would be the appliances, a washer, dryer, stove, refrigerator, but also, okay, whether or not artifacts are going to be included. I've been to listings, and I've had a listing where they had some wonderful, if you know, the old, the ancient, those big flat stones with the curved out middle that were used for like grinding grains in ancient Chamorro times. And these stones are huge. Okay, I had a listing once where they had a couple of these laid out in the yards. So never assume that those are going to go with the property. So it's important to things like that. Also, things to consider when you go for the listing and you're examining the property. Are there features such as crystal light fixtures, okay, enameled outlet, light switch covers, or historic artifacts in the yard? If the owner does not plan to include those items, then my recommendation at the time of listing is have them remove those things immediately, if they can, and replace it with something that they are willing to allow to go with the property. And if they can't do it at the time, then please make a note in the MLS that those items, those personal items, or those personal property, or those fixtures are not included, and that they will either be replaced or left open for the buyer to put their own thing in there, okay? There's nothing worse than something being assumed and then later on becoming a huge issue to affect the ability to close a transaction. And personal property fixtures can do that. I've experienced it, okay? Know the difference between fixtures and personal property. The purchase agreement states that anything that's firmly affixed is considered a fixture, all the way down to things like air conditioners, okay? Usually window air conditioners are not permanently fixed, and they're considered personal property. Split air conditioners, whereas, are a fixture, but we still tend to include them under personal property. but they are considered to be permanently affixed to it, okay? So decide what is included and what is not included with a sale. Next slide, please. As is condition, our purchase agreements right now state within the body of the purchase agreement, the property is being sold in as is condition, okay? However, you need to remind your seller that they still have a duty to disclose known material facts, defects, issues, adverse conditions, or latent defects that affect the value of the house or property or the use of the property, okay? And that the buyer has investigation rights to find out if there are any issues with the property. And if found, it could result in cancellation of the purchase agreement, okay? And that also, just because it says as is, that really means that the seller needs to maintain the property in basically the same condition that the house was in when the buyer made the offer. And that if anything subsequent happens, like a window breaks, they develop a crack in the roof that was not there before, the seller has a duty to take care of those matters unless it's otherwise agreed upon by the parties in writing. Next slide, please. Next slide. Time periods. Now, section 14 of the purchase agreement sets forth the time periods in which the seller is given to complete obligations and duties. And it specifically addresses and makes reference to other paragraphs within the purchase agreement. So pay attention, because the pre-printed, whoops, whoops, okay, whoops, we're going back. Keep going. Next one, next one. Next slide. Very good, thank you. Okay. Section 14 typically gives the seller in the preprint 7 days from acceptance to provide all of these different items that are listed in. Can you back up the slide, please? Go back one. Thank you. Okay. And you need to determine whether or not 7 days is really a realistic time frame in which your seller can perform to provide the reports and disclosures that is being asked of them. And section 14 addresses specifically these things for the seller. Section 4, the allocation of costs for inspections and reports, government retrofitting, escrow, PTR, and other costs. It also addresses the time frame for paragraph 6A, which addresses statutory disclosures, which are lead-based paint and cancellation rights. How many days does the seller have in which to issue cancellation if a buyer doesn't perform? Okay. How many days in paragraph 7A to obtain the condominium disclosures? And also 9A, condition of the property. This is making disclosures of known material facts and defects. Next slide. It also affects paragraph 10A, which basically is addressed more to the buyer, because it talks about buyer's investigation of the property and matters affecting the property, okay? But that really, the seller needs to make the property available to the buyer so that the buyer can conduct their inspections, okay? And 11A are other seller disclosures, and examples of that would be if the seller is going to provide the septic tank report. In one case, I had a buyer who wanted the seller to give a report that all of the electrical in the house met code compliance, okay? So this allocation of time gives your seller a certain amount of time in which to perform and provide all of these things. And so assess what is really going to work for your seller. In some cases, 30 days may be more acceptable for the seller and not make it a big rush, or 15 days, okay? But you as the listing agent need to go over that with your seller and determine what is a realistic time frame for the seller to perform these obligations, okay? Next slide, please. Title investing, okay? What form of deed will best apply for the seller's situation? Will a warranty deed do? That's what the buyer wants, because that is the highest form of guarantee of ownership that the seller can give in a conveyance to a buyer, okay? Or will it be an administrator's deed? Because that's usually what is given in a probate situation. So if that is the case, you want to make sure that it is stated that buyer will receive an administrator's deed versus a warranty deed. Grant deeds are also another form of conveyance of title, not used too often because of the three guarantees that a warranty deed gives. A grant deed just gives two of them, which is basically that the seller hasn't sold the property to anybody else, and also that there are no other liens or encumbrances against the property that have not already been disclosed to the buyer, okay? And what the grant deed does not have that the warranty deed has is that the warranty deed has one more in that the seller affirms and confirms that they will defend their right to convey title till the end in behalf of the buyer, okay? Sometimes a quitclaim deed is the best deed for a seller to execute, only because perhaps maybe they don't have full interest, or it's kind of convoluted, or not sure really how much interest they have. So that might be the more safer deed or better deed for your seller to convey versus a warranty deed. So you need to discuss this with them, and sometimes you may need to pull in an attorney to help them to decide that if their situation is very unique. But be sure when you are reviewing the purchase agreement that you do pay attention to this section on title investing and determine what may be the best form of conveyance that your seller should do. Next slide, please. Okay, sometimes a buyer needs to sell something in order to buy. So if you have that provision in the purchase agreement that you've received, okay, that the buyer is conditioning their offer on their selling property, what you want to do is you want to ask for proof of escrow. Is the property, the buyer's property, already in escrow? Do they have a bona fide buyer? What is the status of that escrow? Have conditions of that purchase been satisfied or released? Or is the property still on the market and it hasn't sold yet? Okay, because if it hasn't sold yet, that perhaps is not the best offer for your seller. Okay, but ask that question, or if you do see that box checked, get proof of escrow. Next slide, please. Repairs. Now, if your seller has agreed to do repairs in the contract, okay, let them know that it is their right to determine and decide who is going to do the repairs for them. But remind them also that the expectation is that the repairs will be done to industry standards, and that it will be of at least the same quality of the rest of the house, okay? The rest of the condition of the house, okay? And that there will be final verification of the condition of the house, and also that agreed repairs were performed in good workmanship order by the buyer. And the purchase agreement usually calls for, I think, 5 days before closing, that they can do within that 5-day period. The buyer has the right to come in to investigate, to make sure that everything is in good order as was agreed upon in their purchase agreement. Okay, but the seller retains the right to decide which contractor to use. Next slide, please. Okay, broker compensation. We talked a little bit about that earlier already. And but always be sure to get, when you present an offer to your seller, to bring along the commission agreement form and insert in there the commission percentage that was agreed upon at the time of listing, or if that's having to be renegotiated, this is the form in which you would put the new renegotiated percentage for commission, and also how the commission is being split in the co-broke situation. Next slide. Other terms to go over with, again, with your seller, you went over it with them at the time that you got the listing to prepare them for this point in time, but explain to them again the role of the title company, how what the title company does, and remind them of the escrow fee that they will pay, how liquidated damages are to be handled, and what happens with that. Again, that goes back to, if there's a default, you need to explain to them how the broker has rights to share in the liquidated damages, okay, that they will receive from a default of the buyer. Also go over them again, dispute resolution. Talk to them again about mediation, the grievance process, professional standard, and lastly, court. We try to avoid having to settle disputes in court, but sometimes it's unavoidable. But it's good to just kind of briefly talk about that to refresh them so that they are aware again. Next slide. And in a multiple offer situation, which I love, this is so exciting when you've got more than one offer coming in at the same time, okay? But sometimes it can be a little confusing and overwhelming for your seller. But if you've been blessed with that situation of having multiple offers coming in at the same time, I recommend that you develop a graph or a chart that shows a side-by-side comparison of the offers, that show the pros and cons, the strengths and the weaknesses of each offer. Okay, this will help you to determine, is there one best offer of the multiples, or do we do a multiple counter offer, which is also an exciting activity to do. It can be very nerve-wracking because the multiple counter offers can be different to each buyer, but it can be a lot of fun too. And when you do this exercise, you help to really isolate, I mean, to weed out and clean out to see which really is the best offer for your seller. Highest price is not always the best offer. You've got to really evaluate all the terms and conditions that are being offered to the seller, and fine tune it to see which one is really going to meet the needs of your seller. Okay, and also when you get in an offer, it's a good thing to sit down with your owner once again, now that you have an offering price, to go back over with the owner what they can expect if they accept that offer as far as net proceeds at closing. Again, you're informing them so that when the closing happens 30, 60, 90 days down the road, they will not be surprised. Okay, Few things may change in between, but there shouldn't be anything so drastic that would change the estimated calculation of net proceeds. But it's a good thing to inform them of that again so that they know what to expect and what they'll be working with at closing. Next slide. And here I've just giving you a sample of a multiple offer situation that I had a few months ago, in what I did in order to show my seller so that when we went over all the offers, because what I do when many offers come in really is I like to present, especially if I know that the offers are coming in within a few days of each other, I like to meet with my owner and present all the offers so that we can determine together and that we don't miss out on really what will be the best offer for my seller. So what I did was I did this side-by-side comparison of the 3 different offers that came in and really addressed the main points of the offer as to such as the purchase price, how it's to be financed, how much earnest money deposit that each buyer put down, what were the days, the estimated days to close, what type of requirements were each offer requiring of my seller, and how much each of those costs were going to be to my seller, okay? And also, if you just read down through it, because this helped my owner to evaluate each offer, okay? And from the computation of the expectations of costs, we were able to come up with what they were going to net at the end of the at closing, okay? And so doing something like this, I think, is very helpful, and I highly encourage you as the listing agent to take the time to do this, okay? Your seller will really appreciate it, and it just kind of lays things out in an easy way to see all the costs and all the requirements, okay? You could study this in greater detail later. Okay, next slide. Okay, and other terms that may need to be incorporated into a buyer for your, an offer for your seller, again, goes back to some of the things that we discussed earlier. If these apply and they were not incorporated into a buyer's offer, okay, is your owner going to do a 1031 tax defer exchange 1031 tax defer exchange, because it will require the buyer's participation and cooperation in executing documents. So do you need to add that addendum in there? Okay. If the property has to go through probate, and if the offer didn't mention that, you need to make sure that language of stating the need for probate and the terms that come along with probate is incorporated into the offer, okay? Addendums, the blank addendum really is a wonderful form where you can insert everything that needs to be included that's not addressed in the pre-printed forms, okay? Also, use the addendum to have buyers acknowledge disclosures that might already been made through MLS in the listing posting, or reports that may have already been provided to the buyer prior to them making the offer. If that's already been done, then you want them to acknowledge receipt of that, okay? That's already been taken care of and it doesn't become an issue or a matter of condition later on in the escrow process, okay? And again, as mentioned, commission agreement addendum to be also incorporated in the offer, or with the purchase agreement, sorry. Next slide. Okay, again, just like with the listing agreement, okay, take the time to explain the terms and conditions of the purchase agreement to your seller. Allow your seller time to review and understand the terms and conditions of the purchase agreement. And as I mentioned earlier, if there are other people, okay, involved in your seller's decision-making process, be sure that those individuals are included in the circle of the presenting of the purchase agreement, going over the terms and conditions, so that they too are on the same page, and that your owner, who is depending on them, will feel confident, more confident really, in making final decisions. Encourage questions. Again, there can never be too many questions, because I always tell my clients, the time to ask questions is before you sign, because once you've signed, then you're bound to whatever was agreed upon in writing. So every question is an important question. Encourage discussion. And again, if the situation calls for it, don't hesitate to tell your seller to take the purchase agreement to an attorney for their review if they want to do it, or again, if there are tax ramifications, to make sure that their tax professional, okay, their accountant, has had an opportunity to review it also before they sign and commit themselves. They'll appreciate your advice on that. Next page. Wow, I'm at the end of my presentation. So I hope that the information provided today, though fast and concise, will be helpful to you. And I really appreciate you for signing up for this class. And I really wish you the best in being the best listing agent that you can be, because you will better serve your clients and our community in doing so. Okay, and that is the end of my presentation.
Thank you, Lou. I want to find out what would you like to do in giving away the raffle prize? Would you like to ask questions, and then that way we can set it up?
Oh gosh, Peggy, I guess I would ask how has everybody else been doing it? I wasn't aware of this until just now.
Okay, I mean, we have two raffle prizes, courtesy of our platinum sponsor for the year, Security Title and ANZ Guam. And we are happy to give away 2 Mescla gift certificates to any winners that will be that you will be considering for today. So I leave it up to you how you would like to test the knowledge of how everyone during your entire presentation. Do you want to go educational, something fun? I leave it up for you.
Oh gosh, Peggy, how did everybody else do it?
Any questions? They did questions, and what I'll do, folks, is I'll open up the chat box like yesterday. I'll open it up, and then Louisa can ask question 1 and then question 2. So for question 1, just simply put Q1 and then the answer, so we can differentiate it with a second question.
Oh wow, okay. Okay, do I just say it?
Yes.
Okay, so I guess my first question would be, who is your owner? There were 10 possible owners. I guess who can name the most?
Name, do you want 3? Is 3 good enough, Louisa?
3, yeah, 3 owners, okay. Yeah, we can do that.
Name at least 3 owners, folks, and put Q1 in the beginning of your answer. Q1 and then 3 owners. Okay, we have POA, authorized rep, owners on the deed. Are those correct, Louisa? POA, authorized rep, owners on the deed.
A POA is not an owner. They are a representative of the owner.
All right, let me try the next one, the fastest. Okay, the next fastest one, it said trust, corporation, seller, partnership.
Yes.
Okay,
That
so
that would be right.
We have a winner. That's Kay Artero of Artero Realty. Congratulations, Kay. We will be in touch. So your next question, Lou.
Okay, next question will be name 3 types of stigmata.
Name 3. Okay, for this one, folks, please put Q2 and then 3 stigmata.
3 types of stigmata.
Yes. 3 types. Okay. So we have suicide, drug, show, shop.
No. Let me see. 3. Okay, there's 3 types. 3. Okay, I'm gonna. These are the category. These are the types. There's criminal, debt, minimal, murder, phenomena, public.
Murder, criminal, debt. Okay, that's the first one. The first one said suicide, drug, show, shop. Okay,
no, drug is a type of criminal stigmata, but it's not. It's under criminal. So, but what I want is either criminal, debt, minimal, murder, phenomena, or public.
Okay, so the second one was murder, ghost, crime. So the third one, the third fastest one, has murder, suicide, criminal, debt. That falls under the type, right?
Yes, those are 3 different types. Yes.
Okay, very good. That's Marilu Laxon. Congratulations, Marilu.
Okay.
So that's it. We have 2 winners for today.
Okay.
Marilu Laxon, thank you. Thank you, Louisa, for being a good sport in that raffle.
Thank you.
The raffle prize. Thank you, folks. Lou, thank you so much for a wonderful class today. I'm sure everybody enjoyed it. And thank you all very much for supporting the Realtor Month. Any last words, Lou?
The Q&A, how do we, I see there's a bunch of questions. I'm sorry I didn't address them.
We can address them. We certainly can. There are still some people that are in, and if there are those that are still in that would like to answer, hear the question.
Well, I know it's almost 12 o'clock, Peggy, and so for the Q&A, is there a way to get copies of the or know what all the questions are that I could address later, or does it have to be done right now?
Normally, the attendees would like to hear the answers to the questions. But we have still over 100 that are on board. If you would like to address a few of them.
Yes, if I can.
Yes, you can. Yeah, we can do that.
Okay. Okay. Okay, there's a lot of good mornings.
Yes, I'm skimming through it so you can see. I
Right.
don't know if,
Okay.
okay, with
So,
your chair.
okay, yeah. Do you have a client pay for PTR? Initially, no, because as you all know, as a listing agent, we normally can get a courtesy PTR at the beginning, you know, at the onset of the listing, but you will always see on the closing statement, though, that the PTR is usually charged to the seller on the closing statement, closing document, a settlement statement. So uh, I do not have the client pay for the PTR at the listing period, but inevitably at the very end, they will end up paying for one.
Okay, thank you, Lou. We have one for Francis Guerrero.
Okay, I think that pretty much, I think it answers the same thing because he asked about a preliminary title report up front.
Okay.
So the answer is, yeah, is no up front, but at closing, usually the seller is charged that by the title company.
Okay, and then there's a question for what website can we find the lead-based paint pamphlet?
Oh, you can just Google really the US EPA lead-based paint pamphlet and it'll come up. That's all you have to, yeah, just Google that. US EPA, that's Environmental Protection Agency, lead-based paint pamphlet.
Thank you, Lou. And then we have a request for your slideshow, which you will be, which will it be okay for us to upload it in our website?
Absolutely.
Thank you. So we can get copies of the presentation. I'm skimming through the other questions.
Me too.
All the recording will be in our website as well, along with the PowerPoint presentations of all the instructors.
Okay.
I think that's it, Lou.
Okay, great.
That's it. We covered it.
Wonderful. Peggy, thank you.
Thank you so much. I appreciate you all. Thank you, Lou. Bye.
Bye-bye.
Thank you.